All right, in this chapter, we want to look at torts. And you might be saying, torts? What is a tort? I had the very same question when I went to law school and I got my schedule for the first semester and I was taking contracts and criminal law and then this course called torts. And I really had no idea what it was. But it really is something that we are very familiar with because a tort is simply a breach of a legal duty that proximately causes harm or injury to another. And by that I mean it's a civil wrong where somebody does something that harms you or harms your property, and now you want to sue them for the damage that they did. So these are civil actions. This is the common situation where you are suing somebody because they've done something that has caused harm or injury to you. The law of torts is not found in the statutory law. It is found, as we've talked about before, in common law. So again, it is developed and built by the decisions of our judges in cases when they've made that ruling, that becomes the law. And the overall area of law is called torts. Now, the next big question is why are we studying torts in a business law class? And there's a really good answer to that as well. If you are out there, there are good in the world of business, there are good chance that at some point one of your employees might do something that interferes with another person's personal freedoms or harms their property or something else. If you own a company and a business and you have trucks and you have truck drivers and they're involved in an accident and they harm somebody or they cause harm to somebody's property, they're going to be suing you for this particular tort. And in fact, or let me say too, if somebody comes into your store or your business and they slip and fall because you had water dripping from the ceiling that you weren't taking care of, they're going to sue you for this tort. And there are a lot of torts that we're going to see in this chapter that we actually call business torts because they are involved in the arena of the world of business. So important for us to really look at these. Now, when we talk about torts, primarily there are two different categories of torts. We have our intentional torts, and then we have what we call our negligence torts, which are unintentional. The difference in an intentional tort, the individual intended their action, they intended to cause the consequences, whereas a huge category of torts, nobody intended to do it, but they were negligent in their actions, and that negligence created a riskful situation in which somebody was injured. For example, when you're driving down the road and you see that you got a text message and you decide to read it on your cell phone, or you decided to return that text, your eyes aren't on the road, the next thing you know, you don't realize the car in front of you stopped. You did not intentionally hit that car, but you hit the car, you did damage, and therefore your damage was due to that negligence, and you can be held liable. Now, why do we sue somebody? Why would you bother to sue somebody who caused you harm? Well, because that usually caused you pain and suffering or money damages. I mean, you got hurt. You have to now buy a new car, get your car fixed in that the situation I just gave. So we are asking in cases of torts, when you sue, you're looking for some type of damages, and those damages are to compensate you for the harm that the other person did to you. We want to make the plaintiff whole again, i.e., putting the plaintiff back in the position they were in before the harm occurred. So in that case where a person ran into your car, you want your car repaired. If you had some whiplash and you had to go to the doctor, you want your bills paid. If you had to miss work, you want to be compensated for those days you were not able to go to work. So we were trying to put the plaintiff back in a position they were in as best as possible before all of that harm occurred. Now, when we talk about that, what we refer to those damages then as is, because they're to compensate the victim, we call these compensatory damages. That's the basic normal damages that we are looking for in a tort action. And that usually means money we want the other party who caused the harm to pay us the money for the losses that we incurred because of their actions. And we divide these compensatory damages into two categories. One is, we call them special or actual damages. They're referred to as either one. But these are really your actual economic damages that you incurred, things that you can bring a receipt for, that you had to pay for the repair of your car, that you had to go buy something new to replace this, or the days that you missed from work. You can actually show evidence of these specific economic losses. So that's going to make up part of the compensatory damages, but also sometimes a larger part of the compensatory damages are what we refer to as general damages, and these are your non-economic losses. I can't bring a receipt in for it, but it's still things that I suffered. So the idea here of pain and suffering that I had. So if you hit my car and put me in the hospital and broke some ribs, then that would be included in that pain and suffering that I had to go through. It can include emotional pain that I suffered, or loss of companionship in a wrongful death action. You're suing because the person had caused an accident and your spouse was in that car and they were killed. You would be suing for wrongful death. For the, you're going to spend the rest of your life without that individual. What about punitive damages? Can we add that in? Now, when we talk about punitive damages, also known as exemplary damages, and we refer to them as exemplary damages because when we give punitive damages, we're trying to make an example of that defendant so that other people won't do that again. So we want them to learn from their example and not do anything, but we also want this to be an example, kind of a beware to other individuals. Bottom line is that punitive damages are rare and rarely given in tort actions, because the idea here is really more just to compensate the individual for the economic and non-economic losses that they incurred. So they can be given only if the jury decides that there was really gross negligence on the part of the defendant and really should be given. But again, the amount of the punitive damages will be watched by the courts, because that's not the point of bringing a lawsuit in a tort action, is not to punish. We leave that to the courts in criminal actions to punish, not in our tort actions. I want to bring up the BUL Wilson case, and this is a case out of 2008 where Bonetta Buell Wilson did bring a lawsuit against Ford Motor, and we're looking at the punitive damages there. The facts of the case simply are that she was driving her Ford. There was a piece of metal or something that dropped out of a car farther ahead. It was laying right there in the middle of the road. She had to swerve to go around it. It was actually kind of bouncing on the road. I think she was afraid it was going to come into her windshield. She swerved the car around, and this was one of those Ford SUVs that were not really built well, so they had a high tendency to flip over, and in fact that's what it did. Her car rolled several times, and if that wasn't bad enough, when it rolled, the entire hood of the car, the top of the car, I should say, smushed in. So she was, her little spine was snapped in about 3 or 4 places. She was now going to be paralyzed for the rest of her life. So she sued Ford for 2 design defects. One is that the car should not have rolled by her actions, and secondly, we don't expect the roof of our car to smush completely in. We expect it to be built so that it can maintain and handle that kind of pressure if the car does roll. Bless her heart, she's coming in every day in her little wheelchair. She was awarded $4.6 million in actual economic damages. This is where she brought in the bills to show what it cost her up to this point. An additional $105 million in non-economic losses. which go to her not only her pain and suffering that she has suffered up to now, that she will suffer the rest of her life. She'll never walk again. She's never going to have that independence. She's going to have somebody caring for her. So all of that 105 million, probably about in the right ballpark. But then the jury added punitive damages to those amounts in the tune of 246 more million dollars, which is more than the compensatory damages combined. And that is what Ford appealed on, is that the punitive damages were way too high. They should not have to pay that. And the appellate court agreed. Again, we try to watch punitive damages in civil tort cases. And they felt that here, the jury was just acting out of much more just emotion and passion of watching this poor woman and what she went through and seeing her every day. And they really weren't valid, so they sent the case back to the trial court to reduce those punitive damages in that case. All right, so let's take a look. And we talked about that we divide torts into both intentional torts and negligence torts. Again, intentional torts are where the individual actually intended the action or intended the consequences of their act. Now, we refer to the person who commits a tort as a new word, tortfeasor. Yes, that is the name. Remember that if you ever see or have that question on Jeopardy, you'll know the answer. But these are what we're going to look at first are what we call intentional torts. And here, these are torts in which the person intended to do the action, to take the action. It wasn't by negligence. They intended the act. We'll start with torts that interfere with personal freedoms, and these cover a number of areas. Let me see if I can get my slide. There's my slide. So let's look at both the tort of assault and the tort of battery. Don't get these confused with the criminal actions that are referred to as assault and battery. These are what assault and battery in the area of tort law, where you as the victim of the assault or the battery can bring this action for compensation against the person who committed the act. And in tort law, an assault is defined as an intentional, unexcused act that creates a reasonable apprehension or fear of immediate harm or offensive contact. So the assault is just somebody doing something that puts you in fear of being harmed. So if you and I had a disagreement and I get really mad at you and I just happen to have a big old bat next to me and I pick up that bat and I come at you with that bat raised like I'm about to hit you in the head, I have committed the tort of assault. And you can sue me for the fact that I put you in that fear of potential harm. So that's the assault. The battery is if I went ahead and hit you in the head. Now I've not only assaulted you because I put you in fear of getting hit, but I hit you. So, and a battery is the intentional, unprivileged touching of another. Now think of that, touching of another. If I hit you in the head with a bat, I obviously have caused you physical harm. But you can commit a battery against somebody by just a touch, and there doesn't have to actually be proved to be actual harm done. And what we're talking about there is the battery committed by just some kind of unoffensive touching. If I'm walking down the hallway and I'm talking to some people and they get ready to go the other way, and before they leave, they just reach out and grab my buttocks and give it a little squeeze. There's no harm done, but is that an offensive touching? I certainly didn't ask for that. I didn't say they could do it. But to determine if it was an offensive touching battery, we do have to apply what we call the reasonable person standard or the reasonable person test. It's not just that it was offensive to you personally, subjectively, but we're looking more objectively. Would a reasonable person in that same situation have found that particular touch to be offensive? So when you are suing somebody for an offensive touching battery, where there was no physical harm done, we do have to apply then that reasonable person standard to determine what, to decide would a reasonable person have considered that to have been offensive as well. All right, so let's go through some examples and see what you think. John threatens Sue by brandishing a knife towards her. He's mad and he takes that knife and he's kind of whipping it right in front of her nose. What has he done? What tort? Assault. Assault only. But if he then whips that around and he cuts her on the cheek, now he's committed an assault and a battery. What if Joe is a little angry at Mary and she's walking out the building and he runs up from behind her and whacks her in the head with his book? Is there an assault there? No. And why is it no assault? Because she didn't see it coming. There was nothing he did that put her in fear of harm. So here we have just a pure battery. And finally, if you're walking along and somebody decides to just grab your little buttocks, we have a potential offensive touching. But again, in that situation, we're only going to win the case and find that it was an offensive touching battery if a reasonable person would have found that touch to be offensive. So we do have to apply that standard to it. Defenses to the torts of assault and battery. One is consent. If we all decide to go out one afternoon and play touch football, we kind of know that you could get hurt. Even though we're just playing touch football, it's still a contact sport. So if we're playing and you run and you touch me, because I've got the ball and I trip and I fall and I break my leg, and now I sue you for the battery, your defense would be consent. I agreed to play football and I knew, or I should have known, that these things can happen. Self-defense. If I'm defending myself from what I consider to be real danger, and I harm you, and then you sue me for the harm I did to you as the battery, my defense would be, yes, I did come and hit you with that bat in the head, but that's because you had a gun and you were coming to me and I thought you were going to shoot me with the gun, so I had a right to defend myself. And my defense was to use some fairly physical force, which was to hit you. I was trying to hit your hand, knock that gun out of it. But again, if you sued me now for that battery, I would defend myself saying what I did in that case was justified because you were coming at me with the potential of using harm and doing much more harm to me. And the same thing is that we can go to the defense of others as long as they would have had a right to defend themselves. If I see a little old lady and somebody's stealing her purse, and then I run and I knock that person down, in the process of knocking them down, they hit their head and they have a nice head injury, and they later tried to sue me for that battery, my defense would be I was in the defense of the little old lady. Defense of property. You're allowed to use reasonable force to defend your property, but you can't use deadly force to protect your property. The only exception to that is if somebody has broken into your house to do some damage. Once they come in your house and you are in fear, you can use deadly force. But if you were sitting there one morning having your coffee before you went to work and you saw somebody was out there in your driveway stealing your car, it's property. You can go out there and you can use force trying to pull them away from the car, but you can't take your gun out there and shoot them because you cannot use deadly force when it's just dealing with property. It's just stuff. All right, another tort that I want to bring up, because it is an important tort when we're talking business law, is false imprisonment. And by definition, it is the intentional confinement or restraint of another person without having any justification. And confinement can be done by using actual physical barriers, locking somebody into something, or physical force, holding up against the wall and not letting them go. And sometimes it can be just done with the fear or threat of force, like saying, I'm going to put you in here, don't leave. And a person's afraid to leave. Now, why do we want to deal with this in businesses? Because shoplifting is a huge problem in our world of business. If you see somebody and you have good reason to believe that they have just put some stuff down their pants or in their purse and are walking out of the store and not going to pay for it, can the store restrain that person that they have reason to believe has stolen and is walking out with goods? And the answer is, from a legal standpoint, yes, that most all states have what they call, for the business in that situation, a privilege to detain, or also known as a shopkeeper's privilege. The key here is that the detention has to be reasonable in both how you did it, the basis of which you had to, the facts you had to believe that they had shoplifted, how you hold them, and the amount of time. Uh, the problem is you always risk that later, if nothing was found on that person, you were wrong, that they're going to probably sue you for false imprisonment. So your defense then would be, I had good reason to believe they did, and therefore the shopkeeper's privilege should protect me from that lawsuit. But let me give you the, let's see if I don't have it on here. Let me give you the Walmart um, case of horrors when it comes to inappropriate false imprisonment. Here we're dealing with a young man, Carl Cockrell, and he came to Walmart this day with his parents. His parents, they all came into the front of the store. His parents went on back to the layaway department where they were going to do some things. Cockrell just kind of stood there in the very front entry of the store for a few minutes and then turned around and started to leave the store. Well, Raymond Navarro, who was the Walmart loss prevention officer, smelled a rat. You know, he saw that Cockrell came in but didn't spend much time at all, and now he was leaving. Did not ever see him near anything or any products, did not see him put anything anywhere, nothing like that. He just had this hunch. And so he goes over and he stops him and he asks him to come to the manager's office with him. Poor Carl was, you know, in his mid-20s. He was a little concerned, but he went with him. I got in there and he said, you know, I think you stole something. And Carl goes, I didn't steal anything. He said, well, let's just check that out. And the next thing he wants to do is have him drop his drawers. And for whatever reason, Carl did. And Navarro was kind of get in there, looked in those pants, made sure, kind of shook his underwear, make sure nothing fell out. Carl puts his pants back on. He said, well, now I want you to pull your shirt up. Well, he had a t-shirt on. And so he pulls up the t-shirt. And there is this huge surgical bandage over half of his body, because it turns out that he had just recently had a liver transplant. And this was the sterile environment for that liver transplant and the reason he just walked into the store and was going back to sit in the car, because he wasn't, you know, still not moving much. Instead of Navarro saying, oh my goodness, I'm so sorry, he wanted him to remove the bandage. And Carl's going, you know, this is a surgical wound and it's in a sterile environment. And if I open it, it's not going to be sterile. And I just had this liver transplant. Navarro goes, I got to check and see. So he did. He opened it up so he could see that he hadn't stolen something and put it in the bandage. Navarro said, well, thank you for your cooperation. You can go now. Well, he went and found his parents. He was so emotionally distraught over this. So they sued Walmart. Yeah, I think they sued them for this false imprisonment and for the emotional distress. And in fact, the court agreed, and he received $300,000 for his mental anguish of that false imprisonment. That's the way not to do it. Bottom line, though, is keep in mind that, before I go to the next slide, keep in mind that in a false imprisonment, if you are sued, you have to show that you had good reason. You saw something on the video cameras. You saw them putting something in there, and they were walking then past the cash registers without going through it. You have to have good evidence that the person had shoplifted. You can't just grab them and drag them back. It has to be reasonable in your belief that they stole something, in how you handle it, and how long they're there. Usually you're going to hold them until a police officer can get there, a very short time. But reasonableness is going to be the key to that privilege to detain. All right, this is really and truly a tort. It's called the intentional infliction of emotional distress on somebody. Uh, it's not, it sounds like kind of silly, doesn't it? Oh, he really upset me. I'm going to sue him for upsetting me. But it is a legitimate tort, and we see it in a certain types of situations and applied because we're talking way more than just hurt feelings here, or upset, somebody getting a little upset here. Here, the individual, the tortfeasor, did an intentional act that we, as a reasonable people, would consider to be really extreme and outrageous conduct that would clearly result in severe emotional stress to a person that you did this to. So let me give you my example. Say that I get home from work. My husband's usually home before me, but on this day, he's not there. And the phone rings. And I answer the phone. They say, "Is this Miss Wetzel?" I said, "Yes, it is." And they said, "This is Twin Cities Hospital. Your husband's been brought in. He was in a serious accident. You need to get here fast. We don't know if he's going to make it or not." And hang up. What am I going to do? How am I going to feel? I'm going to be absolutely hysterical. I'm going to be, oh my God, oh my God, oh my God. I'm going to be getting in my car and driving when I probably shouldn't be. And that's what I do. I'm driving down through Niceville to get to the hospital. And all of a sudden, my cell phone rings and I look and it's my husband's number. And I'm thinking, oh, it's the hospital. They're using his phone to call me. And I answer it and it's my husband. I say, "Hey, I'm home. Where are you?" Turns out that that was a prank phone call. Today, years ago, you might not have been able to figure out who made that call. Nowadays, we can find out who made that call. So if I found out and I sued them for intentional infliction of emotional distress, would I have a good case? Absolutely. Because I think anyone would find that doing that, saying that, putting somebody through that was extreme and outrageous, unacceptable conduct. So let's do a couple of cases so we can see how this is applied in the courts. My first case is Fudge versus Penthouse. Now, I was in the military for a number of years, and all the guys I worked with, a lot of them had Penthouse, and they assured me that the reason they read Penthouse is because it had good articles. Right? Is that correct? Or were they just spoofing me? All right, well, this case has to do with a legitimate article in the Penthouse magazine. They were running a story because at a time there were a lot of elementary schools that decided that the girls and boys should be segregated at recess and should not be allowed to play with each other. So they were finding some of these schools, asking if they could come out, talking to the principal and the teachers about why they had this decision that the kids could not play together. And so they asked if they could talk to some of the children, and they're talking to this group of girls. And the author said, "Well, how do you all feel about the principal's rule that you can't play with the boys at recess?" And all the girls went, "Ew," doing their little thumbs down. And they took the picture. And so in the article in Penthouse, this was one of the pictures they put in there. Didn't name the girls. It just said, not a lot of girls really agree with the the rulings of these principals that they can't play with the boys. Well, Fudge was one of the girls in that picture, and her parents, on her behalf, brought a lawsuit on her behalf for this infliction on their daughter. They said that she was suffering emotional distress because her picture was in Penthouse. Does that really amount to extreme and outrageous conduct that would cause a person extreme and emotional infliction of emotional distress? And the court here said, no, that's not what we're talking about. The conduct itself has to be so outrageous in character, so extreme in degree as to go beyond all possible bounds of decency, and it's kind of regarded as being almost atrocious or utterly intolerable in a civilized community, like the phone call I got. So here they just said, that's not what we're talking about. That's not going to cause us to give money to this individual, because it was just a legitimate picture for saying, I don't like that the principal won't let us play with boys. Now, in the world of business, Sometimes those high pressure tactics of collection agencies, when they do a lot of calling you constantly, 3 in the morning, violent cursing, accusing you of being dishonest, threatening things that really should not be threatened. Courts have held, when people have sued them, have found some of that to be outrageous conduct. However, if they're just forcefully insisting that you pay the money that you owe, even if that causes you personal distress, that's not sufficient for you now to have this tort action against them. Of course, we can't leave this tort of emotional distress without looking at a case against Howard Stern. You just kind of see it coming anyhow. This case was involved his relationship with a young lady who was named Deborah Roach, but he knew her more as Debbie Tay. Um, she was a topless dancer and she loved the Stearns radio show and she called it all the time. And he referred to her all the time as his little space lesbian because she would call the show and talk about how she had been captured by aliens and that, and they'd done things to her and her whole life with the aliens before she was returned. Well, as crazy as all that is, the reality is that Deborah Roach one day died, and her family were very upset of her loss, and they had her remains um, cremated. Now, she had lived with Chauncey Hayden. He was like her boyfriend, her live-in, her significant other for a number of years, kind of almost a common law husband. So they asked him if he would want to have some of her cremated remains to remember her by, all thinking that he would take good care, preserve these in the honor that they should be given. What did he do? Well, he took them. He said, "Why, yes, I would like to have those." And then he calls the Stern show and says, "You remember Debbie Tay, that you're a space lesbian? She was my girlfriend. Well, she's dead. And yeah, I've got some of her remains." And at that point, Stern says, "You do?" So, "Why don't you bring them down? We want to see them." And he goes, "Okay." Well, somehow her family found out and they were trying to get to court to get an injunction. They'd called the show and said, "Please don't do this." And they'd said, "Hey, we'll do what we want." They were trying to get an injunction, could not, and now it's on the TV, on the radio show. Can you imagine what kind of things were said and done there? I mean, you got to just kind of put yourself in this position. Here, here is Howard Stern, a couple of his buddies, and this guy's brought in Debbie Tay's remains. And let me just kind of say some of the things that were said. Starts with, "Ooh, what she taste it? See what she tastes like." And then they pretend to taste her remains and saying, "Ooh, it tastes like Cracker Jacks. Look deeper in the box. Maybe there's a prize in the bottom." And then somebody says, "Ooh, look at those hunks," to which Stern goes, "Look, I'm shaking her bones." And then certain things like, "Wow, she was a nice piece of ash." It gets pretty raunchy, pretty grotesque at that point. In this case, when they filed the lawsuit for infliction of emotional distress against Howard Stern and his show, the trial court threw the case out on the basis that the plaintiff had really not, couldn't even go to trial on this because they had not shown that his action raised to outrageous conduct. So the family, the Roach family, appealed on that they should have a right to have a trial on this and let a jury decide if this was really considered extreme and outrageous conduct. And the appellate court agreed with them. They said, especially because we know Stern's actions, what he's known for, um, in light of his reputation for vulgar humor, a jury could reasonably find that the manner in which he handled her, Debbie Tay's remains for entertainment purposes and against the clear knowing will of the family went far beyond the bounds of decent behavior, and they might award them for emotional distress. So the case was allowed to go to trial, and as far as I'm aware, at that point, the Stern show decided to settle out of court, which was probably a good thing to do. All right, I'm trying to get my next slide here. There we go. Oh, sorry. It's just getting ahead of itself. All right, let's talk about defamation. This is a tort we've heard more about and you might be more familiar with than emotional distress. But defamation is, in fact, simply where one person makes a false statement that ruins a person's good reputation. You are wrongfully harming a person's good reputation because you are knowingly and intentionally saying something that you know to be false. If it is spoken, you say this to somebody else, then it is a type of defamation that we refer to as slander. If you write it, we refer to that as libel. Now, whether it's slander or libel for either one of these types of defamation, the plaintiff to win must show these things. One, that the defendant made a statement that was false, and he did so with the intent to harm the plaintiff's reputation. Second, that there was a publication. Now, this is critical, and why here what we mean by publication is that, excuse me, the statement was actually communicated to at least one person other than the defamed party. So let me give you a couple of examples here so you understand that. If I get mad at somebody I work with and we kind of go into my office and I shut the door and I make a false statement to them saying, well, you know, I and other people, we know that you've been embezzling from this company for a long time. I know that's false. I'm just mad at it. I'm trying to say something hurtful to him. Have I committed defamation here, slander? And the answer is, well, I've met the first one. I made a false statement intending to harm their reputation, but who did I say it to? Who heard it? Just the individual I was defaming. And therefore, I'm not going to be able to bring an action, or he's not going to be able to bring defamation because nobody else heard it. There was no publication, i.e., it was not communicated to a third person. But if we walked into my office and I make that statement and my secretary is sitting right outside my door and she hears that, my claiming he's been embezzling, now we have a case of defamation because we have met that requirement that there was a publication. Somebody other than the defamed person heard this or read it. And then, of course, third, that the statement was such that it could harm a person's reputation. But please understand that requirement of a publication. Again, it's in either slander or a slander or libel. And again, it's that somebody else heard or read that false statement. The defense for defamation, pretty simple, the truth. Remember, defamation is that you intentionally made a false statement. If you make a statement that just happens to be true, and because you found out this person did embezzle, they've already caught him and he's in jail, and you said, did you hear that so-and-so embezzled? He can't sue you for anything because what you said was the truth. So truth is the best defense. Also, if it's just a statement of your opinion, that is not going to be defamation. So if I said, oh, that Lance, he's just a big old fat jerk. It's not very nice, but it's not a basis for defamation. Even if I said it to 20 other people or wrote it, put it on Facebook, it's not defamation because it's a statement of opinion. It has to be a statement of fact. I have to say, did you hear Lance? You know that Lance, he's cheated on his taxes. And I make that statement to somebody else. Now it's a statement of fact. And if I know that he didn't, I'm just making that false statement. Now I am guilty of defamation, or I'm liable for it. The second thing I have up there is a privileged communication. Sometimes in our work, we are required to write, like if an individual who is a manager may have to, on a yearly basis, write an evaluation of the people that work for them. In that required evaluation. They make a statement that was negative, but they're making it in good faith as part of their overall. And it turns out that it wasn't true. And now that person tries to sue you. You might be able to show that this was a privileged communication that you were required to write in the work of your business, and it was done in good faith, and therefore that would preclude the courts from allowing that case to even go forward in the courts. And public figures, when we talk about defamation, uh, our people in the public are defamed every single day. And I mean, they just be glutting the courts that they constantly brought these torts of defamation. So they can bring them. And we've seen some people recently who've been bringing those, saying enough is enough, and they've been very successful. Bottom line is the courts typically, if you are a public figure, you kind of expect a lot of false things to be said about you. It kind of comes with being in the public. But if you want to bring a case, they really they want you to go farther and actually show that it was done with some actual malice, that the statement was made really knowing it was false, or with a reckless disregard for the truth. But that's so it doesn't mean you can't bring it as a public figure, but you're going to raise the ante a little bit before the courts are going to allow you to bring that into court. All right, invasion of privacy is a category of torts that we want to look at. However, what we're normally used to, I think there are, invasion of privacy is where you're suing somebody for intruding on your own privacy, like being they came into your home without your permission, or they're a peeping Tom, or they wiretapped, or they put a camera so they could see you in the shower or something like that. Those are all invasion of privacy torts. However, the only one I want you to really be aware of, and that we want to cover here in this course, is the tort of appropriation of identity. And this is where somebody, usually a business, uses another person's name or their picture or their likeness for their commercial purposes without giving permission to that person. Because this is what we do. This is such a big thing in marketing. Depending on what you're selling, you get somebody who's a great name who helps sell your goods, and they put their name on it and their face on it. And they usually get paid, especially if they're a well-known individual. They make a lot of money off of this. So when you just do that on your own and you don't get the permission from that person and you're not paying them, they could bring this action against you for the tort of appropriating their identity. Samsung got hit with a tort action for tort of appropriation against by Vanna White. Remember Vanna White, Wheel of Fortune? She's done her whole career on that show. But they were doing commercials using a robot that was doing kind of what she does, turning numbers and all around. And everybody knew it was a takeoff on Vanna White. And so she sued them for the tort of appropriation. And they tried to say, oh, no, this was just a little robot. But everybody knew that it was a robot to look like and act like Vanna White, and she won the case. But talk about the biggest, most unbelievable tort of appropriation of identity was done by a few years ago by the company known as Weatherproof. Y'all familiar with Weatherproof? They make jackets, outer clothing items. I was not familiar with them until this happened. Turns out that this was when President Obama, I think it was in his first term as president, and he traveled to China and was at the Great Wall of China. And of course, the press is there, the Associated Press, and they're taking pictures. And they're in the papers and that. And I guess the Weatherproof people were reading the New York Times or the Washington Post, and they go, holy smokes, look at what our president is wearing. And sure enough, he was wearing one of their weatherproof jackets. So they went and bought the photo from the Associated Press. And then talk about tort appropriation of identity. Never talked to the president, but they took this risk. Now, whoever was in charge of their marketing, really clever guy, took a risk, but I think it was a calculated risk. So here is what they did. They bought billboard at Times Square with this picture on it. Weatherproof, our president wearing that jacket, a leader in style. Did they ask the president? Of course not. But again, is the president really going to sue Weatherproof for this? No. So finally, somebody sees it, gets to the White House. The White House calls Weatherproof and go, seriously, honestly, guys, take it down. And they're like, oh, okay, we will. But you know, there's just a minor problem here because we had to pay for this billboard for the whole month and we have to have something on it. And we don't really right now have something that we can put up there in place. So it's going to take us a while, a week or so. In the meantime, now this has made national news. You're seeing all of this everywhere. Weatherproof got their name out there. Best advertising ever. And yet it was all based on a tort of appropriation. Wow. All right, the other torts, let me just go back. Intrusion into a person's affair or seclusion. Somebody puts a little camera in your bathroom and is taking pictures of you, and you find out, you can sue them for this intrusion into your personal affairs. There are other types of also invasions of privacy. I'm not going to go over those. I just want you to know the tort of appropriation of identity. All right, another tort, and we're going to look more at this tort when we get into contracts, is what we call a fraudulent misrepresentation. And a fraudulent misrepresentation is when somebody makes a misrepresentation, either by just making a false statement or omitting a very important material fact. And they do this knowingly. They know they're making this misrepresentation and they're doing it with the intent to deceive the other person. And the other person reasonably relies on what they said to their detriment. So this comes up a lot in contracts. Two parties are negotiating in a contract and the one party makes a misrepresentation. They say something false. Yes, this car has been running like a charm. It is in the best condition, when in fact they know that the transmission's about to ready to fall out of it. The other person, really, it's reasonable. They rely on that. And a reasonable person would have relied on that because it was something that, unless you were a really good mechanic, you might not have realized this. So they rely on it and they enter into that contract. They buy the car and now the transmission falls out. They want their money back. They want the contract to go away. And so they would try to go on that by claiming that there was fraudulent misrepresentation. So now the fraudulent misrepresentation is something they can sue you for in a tort action, and it also becomes the basis for you to get out of a contractual relationship. So we'll look at this tort more closely and I'll give you more examples of that when we get into our contract section of the course. However, right now I do want you to understand that when you can sue somebody for a fraudulent misrepresentation, you have to show that what they said, the misrepresentation, was a misrepresentation of a fact. If it's just the salesman giving you his opinion of how good this product is, that is what we call puffery. And in fact, the law says that a businessman, they want to sell their goods and they can puff their wares. And Prosser, who's kind of the lead legal expert who's written a lot about the law of torts, refers to puffery as, and I think this is humorous but true, it's the seller's privilege to lie his head off as long as he doesn't say something specific, on the theory that no reasonable man's going to believe him or that no one would be influenced by such talk. If you say this is the best computer that's ever hit the market, it's going to do things that no other computer can do, that's your opinion. Only if they make a false misrepresentation of a fact do you now have a basis for a claim of a tort of fraudulent misrepresentation. All right, I am going to stop here And then I'm going to, because we've gone for about 50 minutes, I try to break this down into a couple of sections. So we'll stop here. I will finish up our intentional torts in the second part of this lecture and then go into negligence torts.